Hey everyone, I'm David Finz, and on this episode of the Cyber Insurance Imperative, we're going to take a closer look at a case currently pending in federal court that directly impacts publicly traded companies and the law firms that represent them. The Securities and Exchange Commission has filed an action in the U.S. District Court in D.C. to compel a prominent law firm to comply with a subpoena that demands that it turn over the identities of several hundred clients whose information may have been compromised in a cyber attack on the law firm in late 2020. The SEC is arguing that it needs this information to examine whether any of the material non-public information that was leaked in the attack could have led to insider trading. Not surprisingly, the law firm is resisting the subpoena on grounds that turning over the information being sought by the SEC would require violating attorney-client privilege. That's a position being backed by over 80 law firms who filed a friend of the court brief opposing the SEC's enforcement action. The Association of Corporate Counsel, whose members hail from some of the nation's largest in-house legal departments, filed its own brief supporting the law firm as well. Now, by now you may be asking, what does all of this have to do with cyber insurance? Plenty. For one thing, companies need to be able to trust their outside counsel, and that means not having to worry that their lawyers will turn over any information, even the identities of their clients, that could be used against them by the government. Let's face it, government agencies themselves don't have the best track record of safeguarding confidential data. Just look at the massive breach at the U.S. Office of Personnel Management several years ago, or more recently, at the California Attorney General. If the SEC has reason to believe that a company's stock has been the subject of insider trading, let them build that case using extrinsic evidence, without putting a company's lawyers in an ethical quagmire. I should note that this constitutes my personal opinion and does not necessarily reflect the views of my employer. But there's something else at work here too. All of this courtroom drama is playing out against the backdrop of the White House's new cybersecurity strategy, which was released earlier this month. And that strategy includes a proposal to mandate notification of significant cyber incidents within 72 hours when the victim in question is part of the nation's critical infrastructure. This could place a heavy burden on companies already facing a time of crisis. Cyber insurance is designed to cover the first and third-party costs associated with a cyber attack, including notification of the incident to enforcement authorities, as well as the legal fees associated with responding to a regulatory inquiry. The policy can even pick up fines and penalties where these are insurable by law. But with the added regulatory burdens being placed on businesses, you can expect carriers to start examining these so-called long-tail exposures more closely, and to begin pricing for them or even attempting to limit coverage for fines and penalties. In the meantime, though, companies should ask their outside counsel about the safeguards they have in place to protect confidential client information, and law firms need to up their game with respect to network security and data privacy. Thankfully, the underwriting process can serve as a gut check of sorts to help make sure that your organization has the right controls in place. For a copy of our guide to protecting your organization against ransomware, you can DM me on LinkedIn or email me at david.finz@alliant.com. Here at Alliant, we are committed to helping you find the more rewarding way to manage risk. Thanks for watching.